because it was serious and insulting in nature. It is attacking her morality as a woman. The police officers, X, was merely sitting on a table, eating alone. Here comes a police officer. The police officer has no catch, no person arrested for that day, and they have a quota. If no one is arrested, you will not be promoted. He must have someone to arrest that day, by hook or by hook. By hook or by crook, he has to arrest someone that day. And so this police officer saw someone eating on the table. He could be someone that he needed. And so the police officer went to him and went on the other side of the table, pretending to be talking to him. Thereafter, he seated very near the man. And the man was so pleased, a police officer in uniform was talking with him. But while they were busy conversing, the police officer inserted something inside his pocket. That something was a stolen watch. A valuable stolen watch, the subject of a theft. And he inserted it inside the pocket of the bag of the said man. And then thereafter, the police officer said, "Oh, look at that. That is the stolen watch. You are under arrest because this watch has long been is the subject of theft and the owner is looking for it. You are under arrest. I am arresting you. You have the right to remain silent," and he stated the constitutional rights. And he brought him to the police station. What crime or crimes had been committed by the said police officer? First, the police officer is liable for incriminating innocent person. He planted this watch in order to directly impute upon him the commission of a crime outside perjury. Therefore, he is liable under Article 363, incriminating innocent person. And thereafter, that is now a reason for him to arrest him. You are under arrest. Although in reality, he has no legal ground, he said, "I will be filing a case against you." Therefore, the crime committed is unlawful arrest under Article unlawful arrest under Article 269. So what crime? So, are you going to file 2 cases against the said police officer? You can file only 1 case, and that is the complex crime of unlawful arrest through incriminating innocent person. The act of incriminating innocent person, the act of planting the said valuable watch, which is subject of theft, is a necessary means in order to commit unlawful arrest. So the crime committed is unlawful arrest through incriminating innocent person. But what if the police officers saw X and the police officers arrested X? You are under arrest. We are going to file a case against you. But X said, "What have I done? What case would you file?" You can just explain it in our precinct, in our police station. Meanwhile, we are arresting you and we are going to file a case against you. And then thereafter, they brought X at the police station. At the police station, they told X to place all his personal belongings on top of the table. Afraid, X did as instructed. And then thereafter, placing his wallet there, the police officers took his wallet, opened the wallet, and inserted inside the wallet a stolen credit card. And thereafter, after placing that, the police officer told X, "Now we have a case to be filed against you. You took this credit card, you took this money." And because of that, the said person was placed behind bars. What crime or crimes had been committed by the police officer? The first crime this time is unlawful arrest. The police officer arrested him without any valid ground for the purpose of filing a case against him, for the purpose of delivering him to the proper authorities. Thereafter, when he was already in the precinct, the police officer planted evidence on him by inserting money, credit card inside his wallet. This money and credit card has been the subject of theft. So what crimes had been committed by the police officer? The police officers actually committed two crimes. One is unlawful arrest and the other one is incriminating innocent person. This time, the unlawful arrest was the necessary means to impute upon him the commission of a crime. So the crime committed this time is incriminating innocent person through unlawful arrest. This was a bar problem recently. The first problem that I gave is the common problem given. Evidence is first planted and then he will be arrested. Therefore, the crime committed is unlawful arrest through incriminating innocent person. The act of planting evidence was done before unlawfully arrested him. But in the problem given recently in the bar, I think it's 2015 or 2016 or 2014, what the bar examiner did was that the unlawful arrest comes first before planting on him the evidence. So the crime committed this time is incriminating innocent person through unlawful arrest. Were it not for the unlawful arrest, they would not have planted on him this evidence for theft. And then under Article 365, we have quasi offenses. There are four ways of committing quasi offenses: by committing through reckless impudence, an act which, had it been intentional, would have amounted to a grave felony, a less grave felony, or a light felony. Or by committing through simple impudence or negligence, an act which, had it been intentional, would have amounted to a less grave felony or a light felony. Third, by causing damage to the property of another by means of reckless impudence, simple impudence, or negligence. And lastly, by committing through simple impudence or negligence, an act which, had it been intentional, would have amounted to a light felony. These are the acts punished under Article 365. Under Article 365, what is being punished is the reckless impudence, the simple impudence, and the negligence. Therefore, do not say homicide through reckless impudence. You say reckless impudence resulting in homicide. Reckless impudence resulting in multiple serious physical injuries. The father was about to bring his two young boys to school. The father was on board the motorcycle. And these two young boys were his back rider. They were going down, but there was this van who was coming up. The father immediately saw that the van was swerving. And it seems like the driver was sleepy by the way he was driving his van. And so the father tried to evade the said van so that they would not be hit. Nevertheless, no matter how much he tried, the van still hit the motorcycle. And because of the said hit, the said motorcycle turned upside down. All three of them, father and the two young boys, were thrown on the ground. At that very instant, the father died. The two young boys, however, survived. What crimes had been committed by the said driver of the van? The driver of the van would be liable for reckless impudence resulting in homicide and double serious physical injuries. Even if the injuries sustained by the two young boys were both fatal wounds and they survived only because of immediate medical intervention, it is not frustrated homicide. It is serious physical injuries because there is on the part of the accused no intent to kill. It is a product of imprudence or negligence. If the victim dies, it is considered homicide because intent to kill becomes a general criminal intent to kill. So here, the crime committed would be reckless impudence resulting in homicide and double serious physical injuries. If three died, the crime committed is reckless imprudence resulting in homicide and multiple serious physical injuries. If 2 persons died, 3 persons were injured, reckless imprudence resulting in double homicide and multiple serious physical injuries. What if in the same problem, the moment the father and the 2 young boys were thrown on the ground by reason of the said accident, the said man got out of the van. He was shocked at everything, but instead of giving the first-hand help that he could give, he left on board his van. What is the effect of such act of the offender on his criminal liability? Under Article 365 last paragraph, the penalty will be increased by 1 degree. If the said offender failed to give the first-hand help that he could give to his victims, the penalty will be increased by 1 degree. So in this case, the penalty will be 1 degree higher. What if the accused was driving his car, and while the accused was driving his car, he hit and bumped another car? That other car suffered great damage, severe damage. The driver of the car died. His wife, who was seated next to him, survived. The said driver of the car tried to embrace the wife so that the wife would not be hit. And the wife indeed survived and sustained only slight injuries. And so the driver of the car was arrested and he was brought to the police station. The cases were filed before the fiscal's office. Reckless impudence resulting in slight physical injuries for the injuries sustained by the wife, slight physical injuries. And reckless impudence resulting in homicide and damage to property for the death of the husband, the driver, and the damage to the car. In so far as reckless impudence resulting in homicide resulting in slight physical injuries is concerned, since the victim is alive, it was a subject for inquest proceedings. So right after inquest, that very day, the case of reckless imprudence resulting in slight physical injuries was filed before the MTC. In so far as reckless imprudence resulting to homicide and damage to property is concerned, there need to be a preliminary investigation. The fiscal need to conduct clarificatory hearing because the victim died. There must be the autopsy report, the medical certificate, and likewise, they have to assess the value of the damage caused on the car. Hence, there must be a preliminary investigation. So the case was still with the fiscal's office. Meanwhile, the case for reckless imprudence resulting in slight physical injuries filed before the MTC was set for arraignment. And on arraignment, on the day of the arraignment, the accused immediately pleaded guilty upon advice of his counsel. Since he pleaded guilty, judgment was rendered, convicting him. Judgment became final and executory, convicting him of reckless imprudence resulting in slight physical injuries. After the preliminary investigation, fiscals are given 60 days for the preliminary investigation. Therefore, after 2 months, here comes the fiscal's office filing the case. Reckless imprudence resulting in homicide and damage to property. Upon the filing of the case, it was set for arraignment. Before arraignment, the counsel of the accused immediately filed a motion to quash. Ground double jeopardy. The counsel of the accused said that since the accused had already been convicted of reckless imprudence resulting in slight physical injuries, he can no longer be charged, prosecuted, and convicted of another crime arising from the very same reckless imprudence. The motion to quash was denied by the lower court. It went up to the Supreme Court via petition for certiorari. What was the ruling of the Supreme Court? The Supreme Court said that here, the motion to quash must be granted. According to the Supreme Court, reckless imprudence, simple imprudence are crimes by themselves, Supreme Court said. It is settled in jurisprudence that reckless imprudence, simple imprudence, and negligence are crimes by themselves. Therefore, Since this accused had already been convicted of reckless imprudence resulting in slight physical injuries, he can no longer be prosecuted and punished for another act arising from the same reckless imprudence. Double jeopardy sets in. Hence, in that case, the information for reckless imprudence resulting in homicide and damage to property had been quashed or dismissed. That is the ruling of the Supreme Court in Idler. Is it a good ruling? That ruling of the Supreme Court says that it is settled in jurisprudence that reckless imprudence, simple imprudence, and negligence are crimes by themselves. If there are 100 cases supporting Idler, Supreme Court saying it is settled in jurisprudence, there are also another 100 cases supporting the view that reckless imprudence, simple imprudence, and negligence are merely means of committing a crime. The Supreme Court has not yet set its mind whether it is a crime by itself or only a means of committing a felony. Some cases say it is a crime by itself, then it will be overturned. Then the Supreme Court will say it is only a means of committing a crime, then later on it will be overturned. So both, if there are many cases, there's many cases here. Supreme Court has not yet released, and in both cases the Supreme Court said it is settled in jurisprudence. Because there are really many cases on both views. But they always overturn depending on the facts and circumstances of the case. But I think the better view is the one on Idler, because it is under Article 365 in Book 2, felonies. Therefore, it is a crime by itself. Punished by law, there is a corresponding penalty prescribed by law. So it is a crime by itself. That ends my lecture. And thank you. And good luck on your bar exam. But I think I don't know if I'm going to see you again on, what's this? Pre-lit. So, good luck.